Have a seat.
Everyone please proceed.
If you have a cell phone, please turn it off now.
Again, I'm sure the bailiffs in this courtroom have gone over the rules with you in this court. There will absolutely be no video recorded by any individuals who are not authorized by this court through an approved meeting request. In addition, there will be no outbursts of any kind in this courtroom. This case does present some difficult issues, and we're going to try to navigate through those issues in such a way that are respectful to the person who's missing in this matter. But again, this court will not tolerate any outbursts of any kind. And if there are any such disruptions, this court will hold that party in contempt and punish as according to the law. On the court's docket this morning for consideration is a motion filed by the appellee in this matter in the city of Jackson to revoke a previous bond entered by this court in the matter of the Derrick Coleman as the appellant in cause number 22-887. This court, over the last couple of weeks, has not been able to access a lot of the court records in this matter as a result of the ransomware attack and through documents provided to this court by counsel for the parties. The court will attempt to enter into the record the procedural history of this case. That the documents on file indicate that on or about July 25th of 2022, the appellant, Derrick Coleman, was convicted in the municipal court of the city of Jackson for violation of a protection order. That the order from the lower court indicates that the defendant was sentenced to a period of 6 months in detention and provided an appearance bond in the amount of $2,500, a cost bond rather in the amount of $2,500, and an appearance bond in the amount of $250,000. That the record further shows that on or about August 2nd, 2022, counsel for the appellant filed a notice of appeal from the municipal court to be taken as trial de novo. They concurred with that notice of appeal on or about August 3rd, 2022. Counsel for the defendant filed an emergency motion to set an appeal bond in this matter, wherein the defendant argued that the lower court had issued a constitutional bond that did not comport with Mississippi Code Section 9935(1). That the record does not include any response from the City of Jackson in opposition to the motion to set an appeal bond in his court. That because the emergency motion to set an appeal bond did not satisfy this court's requirement for an emergency setting on or about August 9, 2022, counsel for the defendant submitted to the City of Jackson a notice of hearing on the motion to set a appeal bond for August 10, 2022. That this court, according to the dockets and matters on file, did not conduct a hearing on the motion to set an appeal bond because the parties submitted to this court in order to set an appeal bond, an appearance bond rather, in the amount of $50,000 that was prepared by counsel for the defendant and agreed as to form and signed by the Chief City Prosecutor for the City of Jackson. That order was entered by this court on about August 12, 2022. That included a $50,000 security bond for the defendant and required other conditions a bond for the defendant. Which included requiring the defendant to comply with the no contact order entered in the municipal court, to not return to the marital residence of the parties, further prohibiting the defendant from being in possession of a firearm, and requiring the defendant to be subject to GPS monitoring for a period of 270 days, or until such time that this appeal was resolved. That order was entered on or about August 12, 2022. That the record does not include any other action by the parties in this matter, including any request for a trial setting until on or about September 14, 2023 of this year, when an interim appearance was filed by new counsel for the appellate City of Jackson, at which time the appellate City of Jackson filed an emergency motion to revoke the bond entered by this court. That again, because the emergency motion did not satisfy the requirements for an emergency order from this court, this court required the parties to agree upon a date for this court to hear the motion to revoke bond, and the parties by agreement agreed to the day's date for this court to hear the motion to revoke bond. witnessed any of the procedural history of this case?
Your Honor, I don't believe so, but if I could say for the record, when the order was entered setting the appeal bond, I cannot recall if there was an actual court. Your Honor, I cannot recall if there was an actual court hearing, or if Mr. Gates and I just appeared in this courtroom and submitted an order, but I do believe, Your Honor, that the order was prepared based on the agreement between all of the parties as it relates to the terms and conditions, as it relates to the 270 days or until the appeal is resolved. I just cannot recall if there was a hearing on that matter, because the court, I think in this recitation of facts, indicated it may have just been an agreed order, but I do recall us appearing in this courtroom on that matter. So I just wanted the court to be clear.
Right, but that was the parties appeared and presented this court with an agreed order.
Correct.
Attorney Walker, anything from the state on the procedural history of this case?
Just that we did appear before the court, and I believe that the court gave us reduced it on the appearance bond, and then the defense came prepared that order, and we signed the court to that.
And again, counsel, for the record, was there and I don't have the court docket in this matter because of the technical issues, but was there ever a response in opposition to the motion from the city?
To the motion today?
No, the motion to, I'm trying to make sure that the record is clear in terms of when counsel filed the motion to reduce bond, was there a motion that I may have missed where the city opposed that motion?
No, we came and argued against the motion. What I recall, I was the one who was here to argue against the motion. Verbally, I didn't deal with the motion.
Are the parties ready to proceed on today's motion to revoke the bond entered by this court?
Yes, sir.
You know, we're prepared. We do have an order to this motion to make at the appropriate time.
All right. Appellee may proceed.
Yeah, it's fine.
Counsel, you didn't file a written response to the motion?
No.
Not today. All right.
The court did give some procedural context here, and I would like to give just, as I proceed, I may give a factual context, not to go outside of the way, but only to what's relevant to today. I am attorney Bridget Morgan for the city of Jackson. We're here today on a motion to revoke bond, and for context, Ms. Latasha Coleman filed charges against Mr. Coleman July 16th for domestic violence and malicious mischief. On July 18th, I believe it was, the actual incident happened on July 16th. She filed charges on July 17th. He was then arraigned in the city of Jackson on July 18th. At that time, he signed what was called a no-contact order, saying that he would not have any contact with Ms. Latasha Coleman until the matter had resolved itself. Of course, it doesn't. He was not to harass, strike, assault, attack her in any kind of way, contact her by phone, come to her home, come within 1,000 feet of her. 3 days later, after he signed that contact order on July 18th, he came to her home on July 21st. The allegations were that he kicked in the door, knocked out the hinges. She then came and filed charges again against him on July 22nd, alleging that he had violated the July 18th no-contact order. The city asked that he be taken to custody immediately and held until the hearing. The hearing was held on July 25th, 2022. At that particular time, he was found guilty. The victim testified, Ms. Latasha Coleman, as well as her son and her sister testified at the hearing. He was found guilty and sentenced to 6 months to serve. And of course, the defense did appeal that. At that time, once he appealed, the cost was the issue. We came before this court and we had a hearing on the matter. The appeal suspense for 270 days or until this appeal has occurred. The County of Hinds recognizes 3 companies for the ankle monitoring procedures, contacted the Raymond Detention Center.
I'm going to venture testifying to things such as that the County of Hinds only recognizes 3 companies for monitoring.
Over at this point, counsel.
From my understanding, the county only recognizes 3 ankle monitoring companies, Your Honor. I contacted the Hinds County Detention Center, who also was able to say that they recognize Dep Global, AK Consulting, and Court Watch. I asked them who was he released to. They could not tell me who he was released to. My understanding that some individual alleged that he was released to a Dep Global. We do have a witness here who works for Dep Global who testified that he was not released to them. I also have emails from AK Consulting and from Court Watch who all have alleged that they have not, that Mr. Derrick Coleman has not contacted them at any time since his release to be monitored at all. So the whole reason for this revocation of honors was he failed to sign up for ankle monitoring for 270 days or until the appeal, as he has not been signed as any of the companies that this court or this county recognizes.
Counsel, your motion also alleges that Mr. Coleman that again, the order that this court had prohibited Mr. Coleman from returning to the marital residence after this court's order was entered on August 12, 2022. Is there any evidence that Mr. Coleman returned to the marital home after August 12, 2022?
Not that I can provide with the court today. There are allegations that he did actually come to the home at that time, but I believe that my order related to the no contact order that he violated previously that got us into this court, but I don't have the evidence before me before this court now to say that he's violated the no contact order this court has issued on top of what I was previously put on. I would also like to add that lastly, this court ordered. It is important to know that the defense is the one who prepared the order. The order is very clear, and that this court said that there should be valid with the issue that he will be revoked and returned to the detention center. The city is that he will be returned to the detention center after this time.
Counsel, the question the court has is that this court's order was entered in August 2022. When did the city become aware that it had been in violation of this order?
So he had to come before the city of Jackson on a what we call a status hearing. And at that particular time, he was here for a status hearing, and the defense attorney showed up initially. Then I asked if he should bring his client as well, who was seeking to put a warrant out. At that particular time, there was a lot of commotion over at the city of Jackson's court concerning some of the outstanding charges that had not been able to prosecute, simply because there had been some reason to hold it in advance, not on the part of the city, but for some other reasons. And so at that particular time, the judge at that particular time did not want to take any of this into consideration, and we were told we had to take any matters before the county court. At that particular time is when I reached out. So I can't remember the actual date the status hearing was, but it may have been about a little bit over a month ago that we looked into it and we discovered the violation.
Thank you, counsel. Mr. Stevenson?
Yes, sir. You know, I want to point out a couple things to the court. Now, the court's order that was entered that required my client to be on ankle monitoring, I'm assuming that that's the only thing that we're here proceeding on, because it's, although there were other items alleged in the motion, council opposite did not go into any of those. But I want to be clear about a couple things. Council opposite filed an emergency motion to revoke bond on September the 14th, 2023, which was 367 days after this court entered its order. Now that's extremely relevant, Your Honor. I would point out that when that appeal was filed, if the city was serious about prosecuting this matter, they could have easily obtained a trial setting. One thing that I know about this court is that this court's court administrator is probably one of the best court administrators in the Metro County area. If people notify this court that they need a trial date, they'll, Your Honor's court administrator always times these funds and gives those parties a trial setting. There was no action to move this matter until this court had a docket call earlier, I believe in September, addressing all pending cases on this court's docket. At that time, an attorney from the city of Jackson appeared. They brought no issues before this court about my client being in violation of any term or condition of his bond. There was an agreement to this court that this matter would be set for status on November the 15th, 2023. Your Honor, we did not hear anything else until counsel opposite filed this emergency motion to revoke bond. Now, as the court is well aware, Mississippi rules of criminal procedure govern criminal cases, and they give some guidelines. Rule 8.6 specifically addresses revocation of bond. And it says that the prosecuting attorney, which will be counsel opposite, is supposed to file a motion. And in that motion, it has to state with particularity the facts or circumstances alleged to constitute a material breach of the conditions of release. That's Rule 8.6A1. What counsel opposite has done is filed a motion that alleges no facts. It simply says, as it relates to the order provided that the defendant shall be subject to GPS monitoring at his expense for 270 days or until the appeal is resolved, the city has reason to believe that the order has been violated. Their having an opinion does not meet the rules requirements for facts. They detail no facts that we can respond to, that we could have prepared for this hearing to say, hey, on the day that he was released, he didn't have an ankle monitor, or he was supposed to have an ankle monitor for 270 days. This is the date that it was taken off. None of that is in the motion. How are we supposed to prepare if the prosecution files a motion but does not complete the requirements as required by the rules, Your Honor? And so we believe on that basis that this motion.
Counsel, this court has a duty to enforce its own order. And my order was very clear that the defendant was to obtain a GPS monitor for 207 days until this appeal was resolved. So the question is really pretty simple. Did he obtain a GPS monitor?
He did, Your Honor. His son is here and prepared to testify that he bonded him out of jail, as well as the monitor was in place before he was released, and he had on the monitor for a number of months.
And counsel, I don't know how you want to respond to this question, but I need to know what company this was that he's supposed to have an ankle monitor from.
Of course, it's the same company, Your Honor, that posted the bond with the court. They posted the bond and provided the ankle monitor.
What company is that?
Of course it was. Big D's bill money, Your Honor.
And again, counsel, you tell this court that before Mr. Coleman was released, this Big D's bail bonding placed the GPS monitor on.
Not only before, but just before he was released, but also he had it on for a number of months after his release, based on my understanding. And court,
But again, this court's order said it would be on for 270 days or until this appeal was resolved. And certainly the appeal has not been resolved. So does he still have an ankle monitor?
young man, he does have like a monitor on. Of course, if the court would like him to stand up and show the court, he does have a monitor on. When the court
Is that what I'm saying? Is that the ankle monitor for 15 months?
Of course it is. But it's the Whitaker Monitoring Company. Whitaker Monitoring Company.
So the representation to this court is that initially Big D's bail bond for how long?
Yeah, I know it's Peter Month, I do not have the exact date that it was taken off.
And the current GPS monitoring, when was that put in place?
Yeah, it would have been after the motion was filed and it was brought to our attention that the prosecution had a problem with the monitor not being on, and so he did go and get another monitor. So it would have been since September 14th in our disclosure to the court, full disclosure to the court.
And this court's knowledge of GPS monitoring is that this company, Big D's bail bond, or Wicker, is it Wicker?
Whitaker, I believe it's Whitaker. Yeah, I have the card, and they text me, it's in my phone, I just cut off my phone.
And of course, counsel, the purpose of this court's no contact order and requirement that Mr. Coleman obtain and keep a GPS monitor so that I would know his whereabouts as it relates to the safety of Ms. Coleman. So I guess the representation that you made to this court today is that this court would order Big D's bail bond and the critical bail bond is to submit GPS monitoring for this defendant. I would know what his whereabouts have been for the last 300 plus days.
Well, for the time periods that he had that monitor on, again, before disclosure, there was a period that he did not have a monitor because the court's order said it is at 270 days. So there was a period, I'm not going to mislead the court, that there was no monitor. But those periods that he did have on monitoring through those companies, yes, they would be available to the court.
And counsel, therein lies the issue that I have, is that the 270 days is in place so that parties can bring a matter before this court so that it can be tried timely. And the Supreme Court has said that you try to get these matters resolved within that time period of 270 days, and that's a pretty extended period of time for an appeal from a mechanical matter involving a misdemeanor offense. But the issue that this court was concerned about, and the reason why they included the language until this matter was resolved, is because it did involve a conditional bond related to a no contact order. And what I'm hearing is that at some point, Mr. Coleman, for whatever reason, chose to ignore the language related to until this matter is resolved.
You know, my response to that?
Yes, yes, counsel.
Yeah, I'm going to be clear about something. Because he did not ignore the court's language, because he didn't take the monitor off. The monitor company would have been the company to remove the monitor. And the Mississippi Supreme Court has held, I'm reading a case law, Westerwood v. Wetterbud, 853 Southern 2nd, 826. And in it, the Mississippi Supreme Court held before a party can be found to have violated a term of a judgment, the judgment must be complete within itself, leaving open no matter or description or designation out of which contention may arise as to meaning. That case went on to state a person is entitled to be informed with a high degree of clarity as to exactly what the obligations are under a court order before they can be found to violate the court order. Your Honor, the court order says 270 days or. I think that's extremely important. It doesn't say 270 days and. So because it says or, that in and of itself says that he either has to do it for the 270 days or until the case is resolved. And so based on that, I don't think that he could be found to violate a term of this court's order.
Counsel does a rather novel interpretation of what resolve means. And I'll address that further at the appropriate time. But what I'm really concerned about is when this Big D's bail bond removed this monitor, if in fact it was installed, and whether or not that occurred with that 207-day period. And again, it is unclear what, if any, provisions were taken by the Hines County Sheriff Department to make sure that this monitor was put in place before it was released. So again, I'm assuming that at some point he received this monitor from Big D's, either while he was in Raymond, when he was released and he went somewhere and got it later, I don't know. But I do know the representation made by the appellee that the county utilizes 3 specific bail bonding companies, monitoring companies. And we're pretty clear that he didn't utilize any of those.
Well, I want to be clear, because it's one thing to say that the county only recognizes those companies, but again,
Well, in terms of the ones that the county places on individuals while they're in detention.
yeah. But again, the county was not ordered to pay for this. My client was ordered to pay for this, and so I think it's important because if the court, if it was in the order that these are the only acceptable monitoring companies, then that's clear. That's a clear term. And he would have been required to use one of those 2 companies. However, Your Honor, that was not in the order. And so counsel obviously wants to say, hey, this is the only one that we recognize, or that the county recognizes. Which is that's not in the court's order.
Well, I'm not going to get too far in the weeds with which one he used, but I am interested in getting the records of these 2 monitoring companies, so that I would know what, when and where Mr. Coleman may have been during this time period.
So
When we're now dealing with a complainant who the court has learned through documents presented to this court at the docket call is currently missing. So clearly his whereabouts are relevant. I don't know if he's a suspect and are missing or not. That's not what I'm here on today for.
So if I'm understanding you correctly, the court is asking for certain records, and again, because of the lack of facts and emotion, it was extremely hard for us to prepare for this hearing. But if the court would continue this matter, I'll get the records that the court requests.
But counsel, I'm certainly not going to continue this matter. I'm going to make a ruling today because, again, I think my order was very clear in the was somehow ambiguous or confusing to Mr. Coleman. The court is having difficulty accepting that position. In that I think the order contained plain language and it meant what it said. Certainly if there was some ambiguity as it relates to that order, the prudent thing would have been for Mr. Coleman to counsel to seek further relief from his court if he didn't understand what resolve meant.
You know, there's not a question about what resolve means, but the order says 270 days. So it's not, I don't want to be clear to the court. We don't present to the court that there's an ambiguity about what resolve means. But we also believe just as resolve is clear, so is 270 days. It's just as clear. My question is for one. And judges, I appreciate it through my client. At some point, the monitor company even did reach out to the courthouse. I'm not certain who they reached out, but I guess I don't know if they wanted clarity before the monitor, but they did reach out. My understanding is that after no response was received, I guess that's when the monitor was removed. So again, but I was not personally involved in it, so I don't want to, make any further assurances about who spoke to who. I was not personally involved in it, but it's through my client. But, I think, if I may, I think something is extremely important here. Because this matter is set for status for November 15th. What's concerning to me as an attorney is that the prosecution is here asking for my client to be revoked. However, they've still never asked for a trial setting. Even prior to Ms. Coleman allegedly missing, they never requested a trial setting. And so now they're here asking that my client be revoked. So, on a misdemeanor. Are they asking the court that he be held indefinitely? On a misdemeanor that they're not prepared to proceed on?
Counsel, this court is going to address the issue of whether or not there will be a trial on the violation of the no contact order at the status hearing in November. And I'm certainly not here to tell parties how to present their cases. But I would imagine that the city may argue that there are 20 exceptions to the unavailability of a witness in terms of being prepared to go forward. So I don't think it would be necessarily true that the city couldn't proceed. Courts are always conducted in a manner in which alleged victims are not available. In fact, that happens more often than not.
And this is correct, Your Honor. But what's important is when we were at the docket call in September, again, the city didn't ask for a trial setting. They only asked that this court set it for a status.
And counsel, I agree that the case law and the Supreme Court mandates are quite clear that it is the prosecution responsibility to prosecute cases and bring matters on for trial. A lot of times people assume that we as judges, try cases for prosecutors and the old adage is that, those cases are not moving fast enough, but it's the prosecution's responsibility to utilize the open dates that this court has for trials every month. If you check this court's website, it has open dates for criminal trials monthly, and all that's necessary is for parties to request a trial date. And I can't explain, why the city has, requested a trial date, but I'll address those issues at the November status hearing.
I'll be allowed to respond to the defenses.
You may briefly, counsel.
The defense has alleged that the city has failed to ask for a trial date in this case. Lasasha Coleman filed charges starting in 2022. I believe July 2022 and something before that time. And each time the defense, namely Mr. Stevenson, has come before the court asking for the court to ask for the trial to be held in abeyance.
Counsel, I don't want to deal too far into the matters that are pending in the municipal court.
Yes, sir.
Because I don't know what the procedural posture of those matters are, but I do know that this matter before this court on the violation of the protection order has been on this court docket for more than a year. And of course, as the parties know, the Hinds County filing system is not set up in such a way that I even know when a matter has been appealed. Unless the parties request a trial date from this court, or I schedule what's known as a docket call, the matter may be appealed and I've never known it, because I don't receive that information as a regular part of the filing system of Hinds County. That's an antiquated system that this court has complained about for years. Again, we get for lack of a better word, reputation that the court is not acting on the matter that I may not even know exists. So I'm relying on the parties, especially the prosecution, to request trial dates. And I think the representation made by the counsel for the defendant that in this matter, there has been no request for a trial date from the prosecution.
Can I address that particular part?
Please do.
That particular part is that I was the prosecutor, I am the assistant prosecutor at the city of Jackson, and I prosecuted the violation of no consent order. However, there has been turnover in our office. We do have chief prosecutors as well. As the court is well aware, and the defense is well aware as well, Keith Gates was the actual prosecutor, chief prosecutor at that particular time. He has since left. We now have a new chief prosecutor who is not aware of this case or the facts of this case. So she presented herself, because that is the prosecutor who handles the appeals, to have it reset. It was why she asked for the notice or whatever he asked for at that particular time, and I wasn't aware and I wasn't over here. So there has been some change in leadership and some change in how we proceed with the appeals, and that is why it has not been asked for a trial. Had I been here at that particular time when November date was given, I would have asked for a trial. I have been trying to go to trial on these cases since she had filed these charges. But Mr. Stevenson tries to have it both ways. He asks for things to be held in abeyance, and he says, well, you can ask for a trial, and you're not going forward. He then comes and he says, well, you filed a motion to revoke, but you didn't tell me what you're revoking. However, you went and got your defendant, had him to go and put a monitor on after I filed the motion, so you already knew exactly what I was alleging. More namely, I spoke with Mr. Stevenson prior to this hearing to let him know what I was alleging, so he was aware of that, which is why he then had his declined to go and put a new ankle monitor on. So we asked the court not to allow Mr. Stevens to come do the issue. The issue here is simply that an order that was prepared by Mr. Stevenson has now been violated. So he can't say he prepared an order, now he's not prepared to argue against the order that he prepared. And the defense alleges Whitaker monitoring at some point he alleged Big D's bail bonding. We don't know who these individuals are. This could be Mr. Coleman's friend, somebody who's just going to say, hey, we did put a monitor on him. We don't know what we're about. We have no actual files. No, he hasn't presented to the court any orders or anything to show that Whitaker even exists, that Big D's exist. I believe the county goes through all these stipulations to have different monitoring companies adept, aka Court Watch, for reasons so that it can't be a clown show where we have individuals from Texas or somewhere else and say, hey, well, we have a monitor. This court and law enforcement officers need to be able to follow an individual when they are placed on a monitoring system. So we don't know who Whitaker is, we don't know who Big D is, and for all we know, we just got this monitor when I filed this motion, and now it's 207 days. So our position, Your Honor, is still that he has violated the conditions of the order that his attorney prepared, which is not to have the monitor on 207 days. He can't even tell the court how long he's had the monitor on from Big D, if he in fact had something from Big D. And so we ask that he be held and he be taken to custody immediately for the violation of the order that his attorney prepared.
In the matter of the emergency motion to revoke bond in the County Court of Lyons County, Mississippi, First Judicial District, Derrick Coleman, the appellant, versus City of Jackson, appellee, cause number 22-887. Again, this case is before this court pursuant to the appellee's emergency motion to revoke bond. And that although the motion was styled as an emergency motion, this court found that the applicable rules, statutes, and law required notice to the appellant for hearing on the merits of the motion to revoke bond. And the parties, by agreement, appeared in this court on today for this court consideration of the motion to revoke bond. That on August 12th, 2022, this court entered an order setting an appearance bond for the appellant in amount of $15,000 on a de novo appeal pursuant to an order that was prepared by counsel for the defendant and signed by the then chief prosecutor for the City of Jackson. That in that August 12, 2022 order, the appellant, Derrick Coleman, was directed comply with a no contact order entered in the municipal court unto further order of this court. That the appellee has informed this court that there is no evidence that the defendant violated the no contact order after August 12, 2022. The court's August 12, 2022 order also prohibited the defendant from being in possession of equipment for any reason, to obtain and remain subject to GPS monitoring at his own expense for a period of 270 days from August 12, 2022 or until the appeal in this matter was resolved. That this court, having heard the arguments of counsel for the parties, and considered the relevant law of this case, finds that the appellant has in fact willfully violated the condition of his bond as it relates to obtaining the GPS monitoring until such time that this matter was resolved. And as such, this court also finds that the violation of the bond herein derived from a no contact order, and that the defendant is in willful and criminal contempt of this court. That the secured bond entered for the defendant on August 12, 2022 is hereby revoked, and the appellant is remanded to the custody of the Hinesville Sheriff Department. He will be held with no bond, and the resolution of the appeal agreement. That at the November status hearing in this matter, counsel for the appellant may present any additional findings as it relates to the GPS monitoring of the defendant, such that the defendant may be able to purge himself of contempt of his court. Don't need a rule in order of court this time.
I do have one question. So as we stand here today, with the court being the November 15th, would that remain in statute?
Order is order.
With the court, if the parties in the wheel and trial, if the court entertains an affirmative trial date or within the trial date to the court, so we can get a final resolution in this matter?
I will address those issues all at the same time at the status hearing as it relates to any effort to purge himself of contempt, and also whether or not the state intends to proceed with the trial of this matter.
Thank you.
There being no other matter, the court's not in the court's adjourned.
All rise, please.
Okay.